Bruno, this question comes from Duncan, and it says, what happens if one is informed by an employee of the landlord that they would get a refund of the deposit when they cancel the lease agreement, only to find out later that the lease agreement states otherwise?
So there's different permutations to this type of question, especially because of the way that it's worded. So I'm going to maybe run through one or two scenarios just to kind of play it out. So the simplest of scenarios is the fact that a deposit that's paid by virtue of a lease agreement in terms of the Rental Housing Act has to be refunded unless the specific provisions in the Act that allow for the deduction of the deposit against certain charges apply. And these would be charges such as damage to the property, arrear amounts, and the sort, right? Now, there's timeframes that are allocated or that relate to this. So there needs to be an exit inspection within a certain time of the exit inspection. The refund should be, the deposit should be refunded. If there can't be an exit inspection on the fault of the lessee, the landlord can go in, apply it in a specific way and refund it within a specific period of time. So the first permutation or the first scenario is must be refunded in terms of the Act, unless a provision of the Act allowing the deposit to be retained applies, right? Now, the second permutation is where I'm kind of reading into this. Now, an employee engaging with the tenant always speaks to me of situations where they're trying to get some sort of resolve out of a scenario. So, and the use of the word cancellation as well leads me to think that, you know, there might be a situation maybe of arrear rent or whatever the case is, and now money's due and there's been a conversation about please get out of the property and, you know, we'll make a plan for you somewhere along there. So this is a completely different scenario because the lease agreement is going to obviously, in most lease agreements, repeat what the Rental Housing Act regulations and what the Rental Housing Act says regarding the utilization of the deposit. But between the parties, if an agreement is reached favorable to the tenant, it has to be favorable to the tenant. So you can't contract out of the Rental Housing Act, but you can do so if the tenant actually gains an advantage from contracting out. So if you land up contracting and saying, you know what, I'll pay you everything back. I don't care if there's damage. I don't care if you're in arrears of 100,000 Rand, get out and I'll give you X amount of money back. That is permissible. Now, unfortunately, the question comes in, if there's a verbal agreement that says, I will pay you back versus a written agreement that says, no, the deposit must be applied in a specific way. And the only way to change this is by way of a written agreement changing. There might be a conflict between these two agreements. That's a question of fact that we can't really answer here. Arguably, I would say that the settlement agreement should carry some weight and it should be part of the conversation, because remember how the landlord applies. It depends also on the landlord's application of the facts, knowing how he's actually going to apply the deposit. So even if the lease says he may apply it for damages, he doesn't have to apply it for damages. So my argument would be that this verbal agreement doesn't deviate from the written. It's like an application of what's in the written, but I think it's an arguable, it's something that could be argued either way.